filing, and patent litigation. We are so grateful to have you all here for this program. When we pray, God hears more than we say, answers more than we ask, and gives more than we imagine. So now I call upon Ms. T. Darni of 2nd MLIS to recite our prayer song.
वन्दामहे श्रीमताण्डवन् पादुकाङ्कम् श्रीरङ्गक्षेत्रपवित्रोज्ज्वलपारिजातम् यत्र मानवा सर्वे सन्मार्गदक्षिताः नित्यं पठन्ति ते विज्ञानकलाभाषाः पाठातिरिक्तविषयेभिः प्रवृत्तास्ते सुशीलगुणावपि अनुचरन्ति नित्यम् नानाकलाक्रीडेष्वपि सुशोभिताः सर्वत्र सर्वदा ते आत्मप्रभावैः ओषति वने स्थापित प्रयोगशालासु सम्यक् प्रकाशयन्ति ते स्वप्रभावम् अत्रैवाधीतयन्त्रविद्यासु निपुणास्ते विदेशेऽपि उज्ज्वलयन्ति शालाप्रभावम्.
If the sign on your heart says welcome, the love will come and pouring from everywhere to give such a warm welcome. Now I invite Dr. S. Lakshmi, Dean of Arts and Head of the Department of Library and Information Science.
A pleasant morning to one and all gathered here. I deem it a great pleasure in welcome you all to this two-day webinar on IPR, patent filing and patent litigation, jointly organized by the PG Research Department of Library and Information Science and IPR Cell. Intellectual property protection is a critical for fostering innovation. Without protection of ideas, businesses and individuals would not reap the fullest benefits of their innovations and would focus less on research and development. So that we organize a two-day webinar on IPR. At this juncture, I extend a warm welcome to our vibrant principal in charge, Dr. M. Pichaimani. Welcome you, sir. I welcome our resource person, Mr. M. Mahindra Prabu, Assistant Professor of Law, Tamilnadu National Law University, Trichy. He is the apt person for this IPR webinar. I welcome you, sir.
Thank you.
My delightful welcome to all the participants, HODs, teaching and non-teaching faculties, and coordinator and member of IPR Cell, and I welcome a vibrant students community of our college. Once again, I welcome you all to this webinar. Thank you.
A man of positive attributes and also a man of positive attitude. He is none other than our beloved principal in charge, Dr. M. Pichaimani, sir, to deliver the inaugural address. Sir, mic on.
Yes. Most respected resource person of today's program, respected Dean of Arts, respected coordinators of IPR Cell of our college, respected faculty colleagues, and my dear participants, a pleasant morning to one and all. I am very glad to be the part of the two-day webinar on intellectual property rights, patent filing, and patent litigation organized by the IPR Cell of our college and PG and Research Department of Library and Information Science. The titles IPR, patent filing, and litigation are very famous concepts. Simply saying that which they are protect the legal rights of any creations or inventions resulting from intellectual activity in the industrial organizations, scientific and literary fields. About this, the detailed information will be given by the eminent resource persons with their expertise knowledge. With this, I would like to congratulate the organizers for taking such a good initiative to create awareness and understanding about the IPR. And I asked the participants to make use of the session in a better way. And please carry on the same to your students also. With the blessings of Almighty and our founder, I wish the program a successful one. All the very best. Thank you.
Thank you, sir. Now I call upon Dr. M. Manjula, of Assistant Professor of Library and Information Science, to introduce the chief guest.
Thank you, sir. Mr. M. Mahindra Prabu, University rank holder in BA, BL and ML courses respectively. He received Honorable Justice P.A. Bhagavati Endowment Gold Medal in the subject of Human Rights and International Law. He also awarded Honorable Justice Ramasamy Memorial Award for Best Outgoing Student. He was actively participated various national and international conferences and presented a research paper related to IPR and legal issues. He started his academic career as a guest faculty in School of Excellency in Law, Chennai. He also worked as project associate in MHRD IPR chair, IIT Madras. Property law, intellectual law, and international law are the areas of interest. A man with lots of potential with simplicity. Now I invite our resource person, Mr. M. Mahindra Prabu, Assistant Professor, Tamilnadu National Law University, Tiruchirapalli. Welcome you, sir. It's time for you, sir.
Thank you, ma'am. First of all, I would like to extend my thanks to Dr. S. Lakshmi, ma'am, who have given this opportunity to deliver this webinar address. As well as I have to thank all the stakeholders of stream at Andavan Arts and Science College, Tiruchirapalli. And with its outset, I would like to give a kind of a short brief about patent and why the patent litigation matters. Okay. First, when we look at the concept of patent from the legal perspective, because I'm primarily from a law background, so how we look at it is like from the protective front. So when you look at intellectual property rights as a kind of a subject, there is a trinity in it. One, it is all about creation. So it will be like someone have to create intellectual property. And second, once you create it, you require some protection. And that is where the law comes into the aid. And protection doesn't offer you anything like simply it is like a kind of a statutory right that has been granted. So you do have to exploit that invention. So you have to bring that invention to the market. And while bringing that invention to the market, many players may try to, I mean, the market players may try to copy your invention. They will try to invent around your own patented invention. So it will be like issues arises in the commercial exploitation. And that particular front, we have to deal with litigation part. So these are the three main things like creation, protection, and then commercial exploitation with respect to any intellectual property, and patent is not an exception. And this particular webinar, I'm planning to work on the protection front and then the litigation that comes around that particular issues of patenting with respect to the filing matters as well as to that of the infringement. And for this particular purpose, I have chosen cases from 2015 to 2020 so that that will help you to understand the developing dynamics in this field of patent and how things have been like interpreted very recently by the courts to that effect so that you will also get updated about it. And the patent litigation is a very wide area and we can talk for more than a week or so as to the cases involved. For each and every concept that we have multiple cases with multiple interpretations. So I have chosen certain interesting development for your understanding. before entering into the patent litigation, that we need to have a kind of a basic understanding about the concept and how it works. So primarily, if you look at patent, it is a statutory right. It is granted by the government through a statute. Okay, so the statute that I mean is Patent Act 1970. So a person have to apply for a patent. I mean, the inventor have to apply for the patent. Then only he may get the right. It is not like that inventor immediately after the invention will be granted a patent. The inventor have to satisfy some requirements of law. Then only the patent will be granted. And that requirements, that is universal, because when you look at intellectual property, wherever you go across the world, the norms are like very much uniform. Like with respect to the patent, it is all about novelty, inventive step, and capable of industrial application. These are the three requirements as per law an inventor have to establish so as to secure a patent. So what is novelty? Novelty in the sense it must be something new. Okay, so you can't take anything from the public domain, like what is known to everyone. You have to add something new, which is unknown to everyone in the world. So that is what the novelty term means. And then we have the second characteristic, that is the inventive step. Inventive step is something kind of an acknowledgement from the perspective of the person skilled in the art. So, for example, that you are a person from the field of science and you have claimed that your invention is new. Now, another person from the same field of science, if he acknowledges that this is something new, then you are satisfying the inventive step requirement. And this, from the legal terms, that we call it as a skilled person in the art and science. So that person have to certify that it is new, because for example, that if you are a science student and you come up with an invention, as a lawyer, it may appear new to me, but only when people around you come up with that statement that is completely new, then it is like we can assure that it is something new and it has some kind of an inventive faculty. And then the third requirement is industrial application. So what you create as an invention, it must reach to the public, because this is a kind of a private right and that has been granted by the government for a kind of a consideration. The consideration is public utility. So your invention have to be worked for the public purpose. So you are the one who created it. At the same time, you have to bring that invention to the market. So the public will make use of it and they will get benefit out of the same. So this is the scheme. And mostly that it is like that what we can say is the government provides a kind of a patent right to the inventor for the very reason that the inventor is disclosing the invention to the public, point one. And then that invention is also, that the inventor is also working that invention for the benefit of public. So this is how that we need to look at that particular the system of patent. And then thereafter, we need to get into the very basics of understanding how the litigation comes into the play. Point one, where litigation starts, on what basis it starts. If you are doing the filing for a patent, and if it is been, the application got rejected, then in that scenario, we can say the litigation commences from that very point of it. And one thing that I have to say, there are, if you go to the control of patent offices, there are many applications that has been filed every day. And some of them will be accepted, many of them will be rejected. So the rejected, in the sense, it is not completely rejected. Maybe the controller office, they may think that it is not fit for patent. But if you think that it is a very valid case for the grant of patent, you can very well file an appeal. And if you have very valid grounds for the same, then probably you can get that particular application being granted patent by the controller office through the appellate mechanism. Okay, so that I will explain to you one by one how things works. For that purpose, I am sharing a slide with you. Give me a minute. Let me share the slide. I hope that the PPT slide is visible. Can anyone confirm it?
Yes, sir, it's
Yes,
visible.
sir, it's visible.
Yeah, thank you. So the very first question is all about how the patent litigation arrives. It is like people might have a kind of an thinking that only after the grant of patent the litigation comes into the picture, and then and that too only when we introduce the product into the market. But it is not like that. Okay, even before the grant of patent, the litigation arises. Because when you look at the Indian Patent Act, we have a specific provision, Section 25, Class 1, which talks about pre-grant opposition. What it means, if someone files a patent application and immediately as per the procedure of the patent office, the application will be published in the journal. The patent office runs a journal for that purpose. So all the patent application will be published in the journal. Any interested person, after looking at the journal, if they feel like this is not worthy of grant of patent, they can file an opposition. And that what we call as pre-grant opposition. And if such opposition is filed, then we can say that gives the birth of that litigation. So it will be like two people, they fight for certain kind of an grant of rights. The one say that they satisfy the requirement, the other say that the requirement is not satisfied. So this is how that we need to look at things before the grant of patent. And then the patent is granted. We assume that is a separate scenario. And then it is like we have two more ways in which it can be like give rise to the litigation. Every patent after it is been granted, there is a period of 1 year. The patent office normally provides as per the statutory requirement for the post grant opposition. This is also like any interested person, they can file an opposition against the grant as if it is like something against novelty, inventive step and industry application factor. And then after that 1 year period of time, it is like the post grant opposition that you cannot raise it further. So it is like things got settled. But if you think that after the grant of patent and that too after the completion of 1 year, if everything gets solved, sorry, that is not the kind of thing that we need to go for. After that period, I mean, say period of post grant opposition, we have that revocation as a kind of an litigation subject. Like any person, as per Section 64, can apply for a revocation. Revocation in the sense cancellation of the granted patent. Okay, and they have to file that particular revocation based on certain grounds, that invention lacks novelty or inventive step or it is a prior art, a kind of grounds that one can allege and they can put up an attack on the granted patent. And then normally when we bring the invention to the market, people will try to copy it. And when they do that, we call it as infringement. Okay, so this is how that infringements proceedings comes into the picture. And if anyone does that, immediately we have to file a suit before the district court and then to start our infringement, I mean, commence our infringement proceedings. This way, we can able to protect our statutory right as well as we can also initiate action against the people who does copying without proper license or assignment for that purpose. So this is how that patent litigation have to be understood. Okay, so one part that you have to make it very clear is even before the grant of patent, litigation commences on specific circumstances. Because every patent, when an application, I mean, every patent application, when it is being filed, the statutory opening of pre-grant opposition is there. It is a statutory format, so it will be like no one can evade pre-grant opposition. Okay, so it is a kind of a 6 months window period within which any interested person they can file a kind of an opposition to the application that has been filed for patent. And only after the 6 months period, the controller will take a kind of a decision whether this particular application is fit for the grant of patent. Post-grant opposition is also something, a statutory mechanism. So definitely there will be a window for a opposition. Pre-grant opposition, 6 months window. Post-grant opposition, 1 year window. So this is something, a statutory time limit. No one can change that. And every patent application that has been filed will undergo this particular opposition procedure. What if someone didn't file an opposition, either in the pre-grant or post-grant? Then it is good. It is like without any opposition, that particular patent application has been accepted by the patent office. It is just like in the election part that everyone aware that one candidate will file nomination, and if no other candidate file for nomination, then without any opposition, that candidate wins. Similar is the scenario here in patent also. But here, it is not like the very reason the patent application is filed and there is no opposition, the patent will be granted. The controller of the exam, the particular patent controller, he will examine the patent application. And if he thinks it is fit for grant of patent, then only the grant will be given. Or else he may reject the patent. So he has that particular power. So a third party didn't file an opposition, wherein third party didn't file an opposition, and the application is now before the controller. So can we assume that safely that patent will be granted? Answer no. The controller also will look into the merits of the application, and then he will take a decision, and then only the grant is possible. And if you look at the kind of grant that we provide from the Indian Patent Office perspective, not every application will be given a grant. Out of 100 applications filed, that normally 20 to 30% applications will be given a positive treatment. Nearly 60 to 70% of applications will be rejected. The reason being the want of novelty, inventive and industrial application have to be sufficiently established. Then only the grant is possible, or else the application will be rejected. So this is how that we need to look at things. And then moving on from this, because that I hope that you got some kind of a fair idea about how the litigation come into the picture. And now, when we talk about the rights management, we should also know what exactly the position of law. With respect to the patent, what are those particular legal documents that I have to refer to? Okay, and for which I am giving you some kind of a guidance here. Generally, people will have an understanding or an idea about the Patent Act 1970. That is the very primary source for the grant of patent. Everyone knows about it. But along with that Patent Act, we should also look at the Patent Rules 2003, which recently got amended in 2021. And this particular rules will explain how that filing procedure will take place. And if an opposition is filed, then how to submit a reply statement. Everything as to the office procedure will be detailedly laid down in the patent rules. And apart from this particular patent rules, the patent office will issue a manual as to how the patent office works, what are the practice and the procedure, and if a particular situation arises, how on what basis the patent office will respond to it. That manual is released way back in 2005 and then 2007-8. The very recently updated manual is the 2019 version. You can download this manual and the patent rules in the patent office website itself. And these three, where the Patent Act 1970, Patent Rules 2003, and the Patent Manual 2019, will give you a complete picture about what exactly the Indian patent system is all about, how things works, and how to initiate a process, and how that will be responded by the patent office. And everything will be like you may get a fair idea. As a applicant, because mostly that you are from the background of science, arts and science, so you are the applicant for the particular patent. So you should also aware about these particular procedures. And it is a document available for the public, so you can very well download, have a look into it, do read the document before the filing, so that you will come to know what exactly the system is all about and how it works. And in the year 2021 is very much important for the field of patent litigation. The reason being, the government very recently, they have come up with an ordinance that Criminals Reforms Rationalization and Condition of Service Ordinance, wherein they have abolished the intellectual property appellate court. Earlier, if there is a decision given by the controller, and that is like if the controller reject your patent application, assume that as a kind of a point, and what would be the next step? So your application now been rejected. So is there any way ahead? Yes, you can file an appeal. Where to file the appeal? To the Intellectual Property Appellate Tribunal, and it is shortly called as IPAB. And that appellate tribunal will look into your appeal, and if there is any merit in your application, then they may ask the patent controller to reconsider the decision. So this way things can be sorted out. Now that IPAB is no more, this particular criminal reforms ordinance have rooted out the IPAB, and now the matter will go directly to that of the High Court. So this is the very important changeover, structural changeover in the field of patent litigation, because a forum which been used earlier, now it is not available. So any appeal against the patent controller decision, now it will lie before the High Court for that purpose to get decided. And the decision with respect to the patent is also very much essential to have an idea about how things works. Because if you are in the field of biotechnology, you can go to the Indian Patent Office website, and then you can search for the decisions of the patent controller, wherein you can go for a subject-wise decisions. Like I am from the field of nanotech or biotech, so I want to know previously how the patent office have looked into the patent application filed from my field, so that I will get an idea of how to file my application, or if any objection is raised and how to tackle it. Because the previously granted patent documents will serve as a kind of a guide to the subsequent applicants. So this patent controller decision is of very much value, and it is openly available in our patent office website. And the website is like ipindia.gov.in. And now the said patent office, now they have gone very much digital. And today you can download an Android application, or even in iOS, you can go to the Play Store and you can download the IP India app, and through which you can able to monitor your application. You can also do the e-filing. You don't need to go to the office directly. As well as you can also get to know about the documents that I have referred earlier, the Patent Act, patent rules, the manual, everything is available through that app. So those who are interested in filing a patent, probably they may also download that particular app and make use of that. And this patent controller decisions, it is an open, open system documentation. So it will be like anyone can access it, and they can able to read on what basis the patent is granted. And then moving on from patent controller decision, sometimes the controller decisions will be like challenged before the court, and the court will give their interpretation. And that we call it as judicial decisions. Usually, we rely upon the High Court and the Supreme Court decision on that front. And the decision of the High Court and the Supreme Court are of paramount, and it would be like that I needed to be followed by the patent controller. So this is how the legal resources that we need to look into. So there is a statutory act, Patent Act 1970, and then you have the rules, manual, and then you have the decisions of the patent controller and the High Court and that of the Supreme Court. This is the very basis of any patent litigation. Someone, if they raise any issue, definitely they need to have a look into this legal resources to have a kind of a valid standing before the court of law. So this is the very basic point. And then how and where that we need to file the applications is again another question, because we know how that issue arise and who are the parties to it, and it would be like the what are the legal resources. Now it will be like there is an issue. We know there is a remedy available, but to whom that we have to ask for? Okay. Generally, the patent litigation part, if you look into it, there are two streams. One, it is like from the perspective of the Office of the Controller of Patents. The other one with respect to the district court. So how these two streams works, let me explain to you. With respect to the filing matters, you have filed an application and that application now rejected. So what to do? Whether we have to file an appeal, answer yes, you can do so. There is a right available which you can exercise. Then where to file the appeal? You can file the appeal to IPAB as per the uh, previous procedure. Now it will be like you need to file it before the High Court. And now High Court also rejected your application. Is there any way to file it further? Yes, you can file another appeal to the Supreme Court, and that too on Supreme Court discretionary jurisdiction you can do so. So this is one set of legal forum approach. It arises from the filing matters. So basically, those who are plan to file for a patent, they need to understand this particular procedural part and then the forums to approach for. And then assume the second scenario, like your patent is granted. Okay, so it is like that there is no opposition, and even there is an opposition that has been successfully meted out. So your patent is now granted, and someone is misusing your patent. Okay, and in the sense he is infringing your right. So you need to protect your right, for which you have to go to the district court. You can't go to the controller office because district court is where that you need to initiate the infringement proceeding. And against the decision of the district court, you can file an appeal before the High Court and then to the Supreme Court. So this is how things works before filing and then after the grant of patent. So these are the two streams that we need to understand. Generally, people will have a kind of an idea that whenever there is a problem with the patent filing, we have to go to the district court complex. Sorry, with respect to the patent filing matters, district court has nothing to do with anything. It is only the controller office, they will take that decision. And if you look at the Indian patent office structure, we have limited offices. With respect to the southern zone, we have a patent office, I mean an IP office in Chennai. That is where that you need to file your application. And for nearly 5 states, Chennai office is actually the kind of an forum wherein they can file for a patent application. We are fortunate that we are in Tamil Nadu and the patent office is situated in our very own Chennai, Gindi. And whatever that you want to do it physically to represent your matter, then you have to go to the Gindi office wherein that you can deal with all the matter related to your patent filing. But if you want to do it digitally through the e-filing process, you can do it through the website that ipindia.gov.in, or else now you can able to track everything through the mobile application that is available. So this is the case. And only when the patent is granted, the district court has the jurisdiction to deal with infringement proceedings. So this is the very basic setup that we have as per the Patent Act 1970. But this particular setup will change in the days to come. The reason being, we have the Commercial Codes Act 2015 that been passed and now it is in force. As per this Commercial Codes Act, there will be a district commercial court and then the commercial division of High Court, which hereafter will deal with all the patent related or else IP related matters. Because generally, intellectual property is a commercial property. Okay, so though we look at it from the matter of science, a kind of an innovation, but the innovation is supposed to be used commercially. Whatever the 21st century. And the very nature being commercial, now the Indian court system come up with the Commercial Codes Act that has been established for that purpose. So all the commercial related matters, dispute related matters will be dealt by a separate court established for that purpose. One at the district judge level and then the other one at the high court level with a high court judge that has been appointed for that purpose. And very recently, the Delhi High Court, they have established their commercial division. And I believe that it will be followed up in all the remaining high courts for that particular purpose, and that the entire dynamics as to how and where that you have to file for your IP related rights will change in an year or two. So by 2022, that we will come to know this particular change in the dynamics as to the legal forum concern. So the previous thing like IPB is no more. And now that High Court and the District Court, if you look at it, they have a commercial division only through which that you can able to file your application or petitions for that purpose. So this is the very idea about the legal forum, because this particular 2021 is a period of transition, I can say. There is a change in the way in which the things works. So I think that I hope that you got an idea about that particular change. And then the remedy. So it is like any litigation, people will look for a remedy. Okay. So it will be like what kind of remedy that one may ask for. With respect to the filing matter, the remedy will be like accept my patent application and grant patent. That is the only remedy. And if any of the appellate forum thinks that there is a merit in this particular patent application, then they may ask the controller to reconsider the decision. So this is with respect to the filing matters. But you got a patent in the second scenario, wherein someone is misusing your patent without any permission from you. So he copies your patented invention and he makes money out of it. So what remedy that is available for that purpose? There is a civil remedy. In Patent Act, we don't have any criminal remedy. You can't go to the police station and complain. See, someone is misusing my patent, so I'm here to file the complaint for. Police won't take your complaint for that purpose because the statutory act didn't provide criminal remedy. So only what is available to you is the civil remedy. And in that scenario, I have to explain to you that if you are a owner of a patent, then you have to be the police of your own invention. So if someone is misusing it in the market, then it is you have to do the investigation. That is, the owner have to do the investigation, and then he have to report it to the district court, and then ask the district court to initiate an infringement proceeding. So you can't get any help from that of the police officials for that purpose. Maybe indirectly you may get that, but as per the law, it is like it is a private right. So the private right have to be protected by means of private means only. So there is no way in which that you can get the assistance of the police official for that purpose. And while filing for a infringement suit, it is the owner of the patent who have to submit all the evidences. Generally, when someone does something against us, then it will be like we will go to the police station, file a complaint. The police will do the investigation, they will collect the evidences, and then they will go to the criminal court and then file a case against that particular accused. So that is how things works. But as there is no criminal remedy available for the patent, it is the owner of the patent who have to do the investigation. It is the same owner who have to collect evidences, and then with that investigation and then the collected evidences part, he have to approach the court and then to convince the court there is an infringement happening. And once the court is convinced, then the court will send a notice to the infringer. And who have to identify the infringer? The owner himself have to identify the infringer. For example, if I am the owner of a patent, now I find some person named ABC, he actually misused my patent. So it will be like I have to go to the market, I have to do some investigation, collect evidences against ABC, and then I have to go to the court, and then I have to tell the court, this is the person who have committed the infringement. These are the evidences that I have collected. Kindly initiate proceedings against the person. This is the very nature of the civil remedy part. So it's a bit difficult, but at the same time, as patent being a private right, this is how the system works. Once you file for an infringement suit, there are two ways in which the relief can be looked into. The interim relief, like till that particular suit get end, you may ask for a temporary relief, because you know very well when a matter is filed before the court of law, it may take its own time to get it concluded. So normally, as per the Commercial Codes Act, if you look into it, an 18 months time, almost 1.5 years will take for any patent litigation to get settled. Okay, so in that 1.5 years, anything can happen. Okay, so it will be like if you think that a temporary relief is very much essential, then you can apply for that. And that temporary relief, as per the legal parlance, we call it as interim relief. And what you can ask for an injunction, you may ask the court to stop the infringer from misusing your patent. Okay, so a temporary injunction you can ask for. And then interim royalty arrangements, you may ask the infringer to pay some royalty, and that will be deposited to the court. And once the court gives a judgment that the infringer is the one who does the mistake, then for the period of the trial, whatever royalty that is paid to the court will be given to the patent owner. So this is the interim royalty arrangement. And then if the court is like very much suspicious whether that infringement happened, then the court may ask the infringer to maintain accounts. So sometimes if the court didn't provide injunction, preliminary injunction, then the court may ask that infringer to maintain the accounts properly. So at the end of the trial, in the judgment, things goes against the infringer, then through that particular accounts maintained, the court will come to know what are the profits made by the concerned infringer out of the patent, based on which it will provide some damages. And then basically as a private person, we can't get into the premises of another people. So it will be like there may be some issues in collecting the evidences. So what you can ask for immediately after filing the infringement suit, an appointment of a local commissioner. So usually the local commissioner would be an advocate, and he, with that permission of the court, will issue the places where you suspect that the infringement happened. And then he will go and do an inspection on behalf of the court, and he may also take the police officials for protection. And then he may collect evidences accordingly and then submit everything to the court. So this is something very much useful, because sometimes you may find it hard to collect the evidences. You may not even have a kind of an way to go through those particular process, for which you can ask for a local commissioner to be appointed by the court, and through him that you can able to get some evidences that is record for your infringement. So these are the interim relief. Now, the final remedies. A trial took place. All those particular matters have been discussed upon. And at the end of the day, if the court judges that there is an infringement, then they may issue permanent injunction. So the infringer should not misuse the patent hereafter. And then the court will look into the money that has been made by the infringer through the patent based on his accounts, and then they will provide appropriate damages to that of the patent owner. And the damages would be like nominal, compensatory, exemplary, punitive, as the case may be. Nominal in the sense that you don't know how much damage that you suffered. So the court will give something nominal as it thinks fit. Because as a patent owner, you have to explain how much damage that you suffer. Okay, so through this infringement, I suffered 10,000 rupees. Then the court will grant you the 10,000. But if you don't know what exactly the value of your sufferings, then in that scenario, the court may order, okay, I will grant you 5,000 as a nominal damage. So likewise, the court will give you a kind of a damages, which may be like nominal. And then compensatory in the sense that you have lost this much money. Then in that scenario, the court will give compensation through that infringer on that particular basis. Exemplary and punitive in the sense, if the infringer does it very much intentional, and he repeatedly does that mistake again and again, then in that scenario, he have to be given a punishment for which increased damages will be given by the court. And then finally, the litigation cost, because if you look at the patent litigation, it will usually around 1 lakh to 5 lakhs that you have to spend for the litigation purpose itself, from that initial filing to that of the appellate procedures. So this is something that we need to look at it. And this particular litigation cost, everything have to be paid by the infringer. So that also quite possible under the final remedies things. So this is how the entire setup of patent litigation is all about. The relief that I have mentioned here, that interim relief and the final remedy. These things actually only for the infringement and revocation cases you can ask for before the court of law. Whereas with respect to the controller office, as to the filing matter concern, the only remedy that is available is reconsideration of the rejected application. So that is the difference between the remedy, as we have two different forums to look into the issues separately. So this is the entire picture about patent litigation. Now, I hope that you have a kind of a fair idea about how this litigation works and what are those particular forums, remedy available, and then how things comes into the picture. And apart from that, I would also like to add a few more things. Point one, there is a provision with respect to the kind of revocation and deposition, like section 25 and section 64 of the Patent Act, wherein the statutory act itself will provide on what basis are the grounds on which an opposition or the revocation petition can be filed. And then certain acts won't be considered as an infringement. There will be some kind of a statutory exceptions that has been granted for the purpose. Okay, so that we cannot file any infringement soon, because you need to look at it that intellectual property right dominantly a private right, but the right is granted by the government for the reason being the inventor disclosed the information to the government, because patent act, if you look at it from its very basis, it can also be called as law of disclosed information. Okay, I repeat, it can also be called as law of disclosed information. You are disclosing information about an invention to the government, and for which the government provides you a right, and that we call it as patent right. Okay, and if you didn't disclose to the government, what would be the issue? It could be an invention or an innovation. You have that thing with yourself, but you didn't disclose. You keep it as a secret. Then it is a trade secret for which there is no law to protect it. That you have to protect it through the contractual means. So this is the law of undisclosed information. So trade secret is a law of undisclosed information, but when you disclose it to the government, and if it fit into that criteria that has been given for the patent, then you will be granted the private right without looking into the public aspect also. There must be a balance of private right and public right. That is the reason why in Patent Act we have the compulsory license provision, working recruitment provision. So if anything like the people doesn't have that access to the medicine, or if that medicines are not affordable, then in that scenario a compulsory license can be granted. Way back in 2012, that we have our very first compulsory license issued for in the pharma industry for that particular purpose. So though we can say patent being a private right, the statutory mechanisms are built in such a manner the public right is also getting ensured. So certain acts, though it is an infringement, it can't be considered as an infringement due to statutory exception that is given under the Patent Act itself. And to talk about that, we need a separate session. So I didn't go about it, but I'm telling you what are those particular. I mean, I'm giving you a kind of an idea. There is an exception available, so that you should know as a researcher that you may also make use of someone's patented invention or innovation in your research process. Whether that is a case of an infringement, answer no, because research exemption is provided under the Indian Patent Act. But when you try to commercialize and making use of another person's patented invention, then that is an infringement. Okay, so that we need to look at it separately. And moving on from the statutory exceptions, we have a kind of an certain public interest perspective provisions in the patent law, and that needed to be strictly adhered to. And one more thing, getting a patent is a huge task, but maintaining the patent is another huge task. It is like generally the Indian Patent Office will grant you the patent between in 2 to 3 years time period from the date of your application. So if you think that that's all with the patent office, you are completely wrong. After the grant of patent, every year you have to pay a maintenance fee and you have to file some statements that you are working your patent, and this is how that you does business and the product has reached the public. Likewise, you have to submit some statements periodically to the patent office till the 20-year period of time, because a patent is for 20 years period, and with usually the first 3 years will go for the filing related matters, and after that third year onwards, every year that you have to submit this particular statements to the patent office. What if you didn't file the statements? What would be the issue? Your patent will get lapsed in the sense that you are supposed to pay submit the statement and pay the fee which you didn't. So the right that has been granted to you now become lapsed. Lapsed in the sense you can't make use of that right. For example, if I am the owner of a patent and I didn't pay that maintenance fee, didn't submit those particular documents, now my patent is lapsed. During this period of lapse, if someone infringes my patent, I cannot file the infringement suit. If I go to the court will ask me one particular question, whether your patent is valid, whether your patent is maintained throughout this particular period properly. Okay, patent is valid, yes, because I got the grant of patent. But whether my patent is maintained throughout the period under which that I allege infringement, then in that scenario, I should not get my patent lapsed. I have to maintain it properly. Only when I maintain my things properly in the patent office, I have the right to protect my patented invention or innovation, as the case may be. So this is something that we need to look at it very seriously. Generally, people will file for patent and then they forget about the patent office. And then when some issue arises, when they go to the court, they may not get a remedy. The reason being this, they are not aware about how to maintain that particular patent. They think that it is for 20 years, so hereafter that we no need to go to the patent office. But the 20 years system, how it should be understood is every year you have to renew it. Okay, so it will be like within the 20 years, every year that you should report to the patent office, and then you have to file that annual maintenance fee, as well as you need to file certain other document that is mandated by the patent office for that particular purpose. So this is very much essential. So please do keep it in mind. Things won't get end after the grant of patent with respect to the patent office. After the grant only, for the subsequent years of period remaining, you have to maintain those particular documentation and that annual fee, failing which your patent is of no use. So this is how that we need to look at it. Maintaining the patent and patent itself will cost certain things that we should understand that particular fact. And then some cases that is for your understanding, and that too I have picked up from 2015 to 2020. So let me share how the court have decided on certain issues, and that will help you to understand things better. So this is a 2015 judgment, Merck versus Glenmark. The Delhi High Court, they granted a permanent injunction restraining the defendant from manufacturing the infringing drug and from otherwise infringing the plaintiff's patent. And here, the trial was conducted on an expedited basis within a period of 3 months under the specific orders of the Supreme Court. I have already mentioned in the remedy part itself, once things being proved before the court of law against the infringer, permanent injunction will be granted. This particular case is a very opt example for the same. And the interesting factors, Usually, I say that the patent litigation may go around 18 months period of time or other. But if you think that you have to get it done immediately, you can go to the high courts or to the Supreme Court to ask for a speedier trial. Okay, that is also very much possible. You have to file an application separately, and if the Supreme Court or the High Court consider that the trial have to be completed in a faster period, then they may issue a mandate. And in this particular case, the Supreme Court issued a mandate within 3 months. The trial have to be concluded, and the decision have to be arrived, and the same thing have to be followed in this particular judgment. Okay, and the related trial process. And then Novartis versus Cipla. And this is also an interesting one, which is a 2015 judgment. And here, an interesting thing comes into the picture. The Delhi High Court said that they can grant relief to the patentee regarding the valid claims, even if it invalidates some claims. You may have a doubt, what is this claim is all about? Claim means that you ask for some rights, okay, with respect to your invention or innovation. Okay, usually the claim part is very much important in the patent document. If you claim something, then you have right. If you didn't claim, then with respect to the invention, you don't have any right at all thereafter. It is your own invention, but you should know what you should claim and what you should not. Okay, so that is very much important. Every patent application will end with claims. Okay, this is what I want with respect to my invention. My invention does this, does that. That is a claim. Okay, and if anyone copies my invention, then the court will look at your claim document, and then that infringes activity. And if the infringer activity fall within your claim document, then in that scenario, the court will decide that is a clear case of infringement. But that is an infringing activity, but you didn't claim, you misdoubt it, then it is not an infringement at all. So the claim is very much important. And sometimes the patent applicant will claim many things. Okay, so he may claim some 10 to 15 things with respect to his invention or innovation. But the patent office or the court may accept only few and reject other. It is up to the court to take the decision. So if one particular claim is rejected, that doesn't mean every claim is rejected. So if a claim is rejected, then if any other claim that is valid, based on that particular claim, relief can be granted. So this is what given in section 114 of the Patent Act 1970. Okay, and that is what iterated by the Delhi High Court in this Novartis versus Cipla. So as a patent applicant, you can claim many things, but it is up to the court to validate some and invalidate other. But you definitely have a relief. That is something through the validated claims you can claim. So this is how the section 114 talks about, and through which here the court also affirms that said position of law. And this is a 2015 judgment for that particular purpose. So you file a patent application and you put forth some 10 claims. 5 claims got rejected, another 5 claims got accepted. Then you have a remedy with respect to the 5 claims that is accepted. Don't think that if a claim is rejected, that your patent itself is rejected. That is a kind of a wrong interpretation. And that is what this particular judgment confirms. And then we have the Roach versus Cipla. It's a very important judgment. We can refer this judgment for 2 different things. One with respect to the claim interpretation, and then the other one with respect to that of the remedy that has been granted for that purpose. Okay, so the claim interpretation here, if you look at it, the court says that the broader structure of the set of claims is an inverted pyramid with the broadest at the top and the narrowest at the bottom. Claims are a single sentence defining an invention or an inventive concept. So, as I said earlier, what exactly a claim is, it is what your invention does, the activity of your invention. That is what you can claim. And different claims define different embodiments of the same inventive concept. For example, you created a machine, and the machine can perform varied functions. each and every function is a claim that you can very well put forth in your claim document. And then the claims are divided into two, independent claim and the dependent claim. Independent in the sense the character is very much independent and it can do things on its own. Dependent in the sense there must be some kind of an dependency that you can see. So it will be like only if it occurs, this particular may be open-ended or closed. So it will be like what exactly it is and how it performs and what are the functions that is associated with it. And that we need to make it very clear. Sometimes a claim will be like, will be open-ended in a sense, you can able to add things later. If the claim is close-ended, in the sense you can't add things later. What is stated, that is how it should be. So it is all about how we interpret the claim or how we draft it. Okay, so that's something that matters. With respect to the filing of patent, only a patent agent can do that. So as an applicant, so if you are interested to file a patent, you have to sit with your patent agent because the patent application is a techno-legal document. It is a mixture of technology and the legal content that comes in aid for its protection. Okay, so the patent agent, though he is a person well versed both in technology and law, it is like as an inventor, you have to sit with the patent agent while drafting your patent application, and you have to make clear what are the claims on what basis it should be drafted. That is how that you can set the boundaries. For example, you are going to buy a piece of land, and then how you define the boundaries. To the west, someone is residing, to the east, to the north, to the south, that we will set out boundaries, right? Then only that we can say this is my land. This usually happen when we buy any piece of land for any purposes. Similarly, with respect to the patent also, we need to set the claim very clear. That is the reason why that you can able to portray this is what your property is all about. The boundaries of your property will be laid down through the claims. Okay, so that is something very much important, and that is what the two-judge bench of the Delhi High Court, they have laid down this particular broader structure with respect to the claims as an inventive permit, and this is a very important judgment for that particular purpose. And then again, in the same case, the appellate court find that the defendant had infringed it and the patent is valid. But the sad part of it is only 3 months left in the life of the patent. So as I said earlier, patent is only for 20 years period. Now it will be like almost 19 years and 9 months have gone. What is left over is a 3 month period. So the court thought that injunction, providing injunction doesn't serve any purpose. So the court instead ordered the defendant to render account of the profits, which I have said earlier as to the remedy part. Okay, so it will be like depending upon the situation, the court will provide remedy. So if you are even if your patent is about to end, you can file for an infringement. Some may put forth a question, sir, my patent got expired. Whether I can file an infringement suit? That is a possibility. For example, you filed a patent in 2001. Your patent will get expired in 2021. Just 20 years period assumption. Now, in 2022, in the next year, probably, that you come to know someone is misusing your patent, misused your patent. After 2021, it is in public domain. Anyone can make use of it. And when you do a kind of an investigation, that you find out that the said person is infringed your patent from 2015 onwards. From 2015 to 21, your patent is alive. But now it got expired. Now can you ask for any remedy? Answer yes. The law permits you to do that. So for the period wherein that you are entitled for the patent protection, even after the expiry of the patent, you can claim remedy. This is quite possible. Okay, and Roach versus Cipla case, wherein they say that even at the end of your patent lifetime, you can claim remedy. Now, as per the statutory position, I can also give you another interesting fact that even after the expiry, for the period under which your patent is alive, if someone does any infringement, you can file for remedy before the court of law, provided it must be well within the limitation period. Generally, in filing the patent, any cases, the limitation period will be taken into consideration. Like within 3 years from the date of occurrence, one have to approach the court. The said limitation rule is applicable. So even after the expiry, but within 3 years from the date of occurrence, date of knowledge of that occurrence, if you file the infringement suit, for the period under which the patent is protected, you can very well get the remedy. This is possible under the Patent Act 1970. And then this Phillips versus Amesto, it is a very important case. It's a 2019 judgment in which the court introduced the concept of aggravated damages. Okay, so aggravated damages, it's like someone intentionally, and that too with a bad intention, he does infringement. And it is like he does that mistake very much intentionally and wantonly. He knows what he is doing and he knows it is an infringement, but he does that. Then the court comes to an understanding that these people have to be dealt with a kind of a stringent manner. So they say that if there is a damages of about 1 lakh for your intention, that malified intention, the court may grant 5 lakhs as damages, 5 times the normal damages that is being assessed for it. That is very much possible. And the Phillips case is a very good reading with respect to the concept of aggravated damages. So that is something very interesting that happened in the year 2019. With respect to the trademarks that we have seen a lot of such punitive damages that has been granted way back in 2015. But as to the patent issues concerned, this Phillips case is something, an important judgment to that effect that happened very recently. And then we have the Shogun Organics versus Gaur Hari Richard. It's a 2019 case wherein the Delhi High Court held that the prior disclosure of the invention during preparatory steps taken for launching a product, such as disclosure to the government, cannot help to be constitute disclosure for the purpose of anticipation unless until there is a clear public disclosure of the same. Okay, so one thing that we need to know with respect to the patent filing is, on the date of filing your patent application, your invention must be a secret. Only you should know about your invention, and you should not disclose it to any third person. If you do so, your novelty will be attacked. Okay, you are submitting to the government, to the patent office, the information that you provide is completely new. No one have any idea about it. Then it must be secret, even though that you have you have invented it or innovated it a year before or whatsoever the case may be. But you have to keep it as a secret till the patent application is filed. Your invention or innovation must be secret. If you disclose it to any person, like some media, they came for an interview as to that they come to know that you are working on a particular interesting invention, and you disclosed certain things about your inventions in media, then you itself killing your novelty. So you have to be very clear that till I apply for patent, I won't speak about it. Only after the application is filed, I will speak upon my invention. That is the best way to handle things. But sometimes when you are working for working on an invention or innovation, you are supposed to disclose certain things to the government to seek permission or certain other things. Maybe some restriction imposed by the government for that purpose. Or else, if you want to launch a product, you need to get clearances from the government. So you need to submit some information. Whether that will be considered as a kind of an disclosure, the court said no. Any information submitted to the government will be considered as confidential. So the information submitted to the government cannot be considered as something disclosed to the public. So the novelty remain valid and there is no problem at all. The High Court also held that the disclosure to the government department or any other authority, not just of the patentee, but by any other person would not constitute pre-publication. For example, you are working in your office, someone who works under you knows about your invention or innovation. And if he submits any information about your invention to the government, whether that amounts to disclosure, no. So either you or by any other person, if they submit any information to the government, that is not at all a disclosure. Your novelty remain valid. You can apply for the patent. So this judgment encouraged the applicant, for example, in the field of pharmaceutical, because the people have to follow the due government regulations without the fear of undue disclosure of their invention. For example, in COVID-19 situation, many pharmaceutical companies, they are working for vaccines and cures. And we come to know some informations earlier in the period of pandemic, like certain vaccinations, certain vaccines were being tested, and the results were seems to be very much positive and productive. Those informations are like actually submitted by the pharmaceutical company to the government, and then it comes to the media. Okay, and these people, they have to do a lot of phases of trials, then only they can show their efficacy. Today we say that Covaxin or Covishield is 81% efficient, 90% efficient, or 60% as the case may be. How they can claim it? Only when they do some trials. Okay, so they have to do some trials. The trial data have to be submitted to the government, and then later they will apply for a patent. When they apply for a patent, the information that is submitted earlier by them to the government won't affect their patenting. Okay, so this is what in Shogun Organics Limited, the Supreme Court, sorry, the Delhi High Court made it very clear, and it is a kind of an encouraging judgment. So it will be like we should not have any fear in submitting information to the government. That won't affect our patent application. That one have to be very clear about. And then Ferry Dalani versus Union of India, it's another important judgment I can tell you. It is on computer softwares. And this is a very interesting development. And I mean, so far, the software patent is a kind of an gray area. People used to say that in India, software patent is not granted, only copyright protection that you can avail for. But when you look at that provision, section 3K, it says that software per se is not patentable, but embedded software is patentable. If a software works along with the machine, then both the machine and the software is patentable because they produce something as an output. Okay, and this has been a kind of an interpretation. But in Ferry Dalani versus Union of India, the Delhi High Court, they put forth a landmark judgment. They stated that if a software produces a technical effect or a technical contribution, then it is patentable. You can't said, I mean, the patent office cannot say it is software per se, so it is not patentable. Okay, so that is the case, or that is the very change in that particular mindset of the courts as to the software patenting concern. But the problem being like the patent was granted to that particular software just 5 months before expiry, because the patent application was filed way back in 2000, 2002, 2000 itself, that we can say. 29/12/2000, Ferry Dalani from France, he filed that application before the Indian Patent Office. But the judgment was taken only in, I mean, the grant of patent was been given only in 27/2020, just 5 months before the expiry. There is no other go, because sometimes a patent litigation, it may take the entire 20 years period of time. Then in that scenario, it will be like no use of getting the patent. Example of which is Ferry Dalani. But the interesting fact is he have put up a very good fight, and ultimately that now any person, any inventor who comes up with a technical effect can get the patent very easily, and that too within 2 to 3 years time. So even though he lost the particular thing, in a sense, just 5 months that he can enjoy the patent, because the patent term period will be calculated from the date of filing. okay, not from the date of grant. So he filed it in 2000. So he got that grant only in 2020. So almost 20 years gone. But this is a very valid fight, and what he does is like have changed the very landscape of software patenting in India. And what exactly this technical effect or the technical contribution, the IPAB have given some factors. So if anyone from the field of computer science, please do have a look into it. So if you can able to showcase higher speed, reduce hard disk access time, more economic use of the memory, more efficient data compression techniques, improved user interface, better control of robotic arm or any other robotic part, and improved reception or transmission of a radio signal. If you can able to improve things in this manner, you are actually showcasing the technical effect. So that is patentable. So this is what IPAB have interpreted, and this is only illustrative. Depending upon your invention, the IPAB will assess things individually, and they will, that patent office will assess things individually, and they will provide you that whether on what basis they are accepting it, and for which they have issued a guidelines also. If you look at the computer-related invention guidelines 2017, you will have a very idea about how to apply for software patent in India. So if you read this particular judgment as well as the guideline, you can very well come to know what is patentable and what is not patentable with respect to softwares. So this is a very interesting development, took place in 2020, just a year before. So please do have a look into it. And then Bayer Corporation versus Union of India. And this is what the statutory exception that I have said earlier. The division bench of the Delhi High Court, they have upheld that export of the patented invention for experimental purposes. For example, if for a research and experiment, if you make use of a patent, it is not an infringement. That is what the law says. But what if you are that it will be like that whether you can able to do that research and experiment beyond India. For example, India and China, two researchers, they do collaborative research, and for which they make use of the patented invention. Whether that is a case of an infringement, answer no. And here, if you look at it, India follows the Bolar exception, and here they say that within the country and abroad, it was authorized and very much legal. And another thing, this is a kind of a second round of compulsory license case, because Bayer already lost the case with respect to the compulsory license. NATCO got that order in its favor. The NATCO was working on Bayer's chemical compound, and now a Chinese company, they express interest over the NATCO's chemical compound because they want to experiment it further and then to improve it. For that purpose, they have asked for some kind of samples, which NATCO about to provide and Bayer opposing it. And when the matter goes to the court said that this particular export is very much legal and it is for the experimental purposes. So no one can claim infringement. So this is also an interesting development. Collaborative researches. So here now your college may do a research, and tomorrow they may have a collaborative MOU that may sign with some other institution, educational institution or a research center abroad. And when you do some collaborative research, you may also come across situation like that, wherein that you be very much confident as to Indian patent law, experimental purposes, that you can very well make use of a patented item, and that is not a case of an infringement. So this is a very important judgment to that effect. And then we have the Sterlite Technologies Limited, and it's also something with respect to the injunctions, that is the interim orders. And here, though the court say that the preliminary injunctions are need of the hour, they say that the courts may prefer to fast track the trial instead of considering the preliminary injunction, because sometimes the accused person, that is the infringer, he doesn't even infringe at all. But throughout that period of trial, he will be barred from doing his activity. that is completely an injustice. So the court is of the opinion here, like though it is a need of the hour, the balance of convenience have to be looked into. So injunction won't be granted immediately. The court will look into the fact, and if the court is satisfied, then only a preliminary injunction will be granted. So this is also an interesting development. Nowadays, many foreign companies they usually get patent in India, but they won't even uh, market it in India. They just get a patent. It's a document, simple. But the product won't be available in the Indian market. It is nothing but non-working of the patent. Some Indian companies making use of that opportunity. Now, what they usually do is they will manufacture that particular patented one because information is available in public, and they manufacture this, they make money out of it. So it is like a case of an infringement, but they say that earlier the court also have look at it from the public interest perspective. When a patent is granted, then it must be worked for the Indian public. If you didn't work it for the Indian market, you just get the patent, then what is the purpose of granting it? So those who didn't work the Indian patent, definitely they don't have any remedy under the Indian patent law. So that was a kind of a stance taken by the Indian court way back in 2006-7 itself. And the Francis Xavier Huma case is a very good example for that. But now many foreign companies having known about the Indian court practice, they used to claim that they are about to launch. They take some time to launch the product, but during that period, the Indian company does infringement. So the courts now they are like planning to provide. I mean, in a sense, they have even provided interim relief on that particular scenario, provided the patent owner must give the kind of an indication, positive indication, that he is about to launch the product in the Indian market. Only on that particular assurance, injunction will be given. If he have no interest to launch his product in the Indian market, then the court will not provide any kind of interim relief for that purpose. And this is it. And I hope the time is up, and I think that we can have some kind of a discussion as to the cases. Though we have some 3 to 4 cases left, I think it's good to have some discussion on this front. And floor is open. You can pose any questions to me as to the patent litigation, whatever discussed, or else any other doubt that you have. I will try to answer the same to the best of my knowledge.
Sir, good morning, sir.
Good morning, sir.
Yeah, very informative and in depth about the legal procedures of patenting. Thank you very much for the informative session, sir.
Yes.
Hello? Am I audible, sir?
Yes, you are audible.
Okay. So my basic question is, if my patent is rejected, hello?
Yes,
If
sir.
my patent is rejected, if my patent is rejected by the controller office, should I go any legal procedure or should I continue with the patent office, sir?
See, if your patent is rejected, you can very well represent the same before the patent office with suitable amendment to your patent application. Because sometimes the patent office may not consider your application on certain issues. So if you work on it and then represent it, definitely they may accept it. But if they patent office completely reject your application, then probably you can go to the appellate board. But now the IPAB is no more, so you can very well go to the High Court in the place of IPAB, and you can ask for a consideration of your application by the patent office. And if the High Court is of the opinion, or the Supreme Court, as the case may be, if they think there is a merit in your application, definitely the patent office have to reconsider it. In the past, such kind of application rejected by the patent office on appeal to IPAB or to the High Court, when the court remanded it back to the patent office, the patent office also have granted. So it is not like that the decision is taken by the court on this record. The court will ask the patent office to reconsider on certain points, which they think that as per law, the applicant is eligible for patent. But if the patent office thinks that that is not something eligible for patent, they have to record reasons for that purpose. So simply they cannot reject. So when a matter is preferred by means of an appeal, then everything have to be like recorded formally. So that is one opportunity that you have as a kind of an appellate mechanism under the filing process.
Thank you, sir. Thank you, sir. Similarly, if the patent is misused, should I check with the patent office or should I go for a legal procedure, sir? If patent is misused.
Sir, if your patent once granted and it is misused, patent office have nothing to do with it. You have to go to the legal mechanism, like you have to go directly to the district court and then to file a suit for that purpose. Because only with respect to the filing related matters till the grant, the controller office will assume the court of first instance. That is the way in which that we say. Whereas once the grant is provided, it is like patent office is done with. So any issues with respect to the granted patent, you have to go to the district court, because that is the court of first instance after your right is cemented. Because once the patent is granted, you got a statutory right. And any issues thereupon, now you have to go through the district court, that is the court of first instance. And if the infringer, if he challenges your patent, this may also happen. For example, that you may accuse a person of infringement. The said person again will question your patent itself. So that is what we call it as counterclaim. You claim him as infringer and he counterclaim your validity of your patent. Then, as to the validity of any granted patent, district court don't have jurisdiction, but the high court will have that. So immediately when a counterclaim of such nature is filed, the district court will transfer the proceeding to the high court. And the high court will take the decision, because high court is superior to that of patent office as well as to that of the district court. So the high court being a common ground for both and as a common appellate forum for both, they will take that particular issue forward and they will decide upon things.
So thank you very much for the clarification, sir. Thank you,
Yes.
sir.
Any other questions? One interesting question, I think that I have seen that in the chat box. What is the difference between patent litigation and patent prosecution? As I said, with respect to the filing matters, anything that has been been submitted before the controller office or to the appellate forums, we can call that as patent prosecution. So something if we want to obtain protection for a patent. And patent litigation, in the sense, we can say that something that happens after the grant of patent. So the two differences that we need to know very clearly, and that is what I try to explain in the very initial time. It's like there are two branches with respect to the litigation part. One, it is like with respect to the filing matters, that is prosecution, and the other one, it was after the grant of patent infringement, and that we call it as litigation part. But sometimes these two also will get mixed. Like when an infringement suit is filed, and then the counterclaim as to the validity has been raised, then in that scenario we have to consider both. So that is the kind of beauty of this particular system. I hope I have answered the question as raised by Dr. P. Tirumalai Vasan for that purpose. Is there any other questions?
Thank you, sir.
Yeah.
Finish பண்ணிக்கலாமா?
Yes, ma'am. If there are no questions, we can. Right.
Okay.
Okay. Thank you so
Karunanidhi
much,
sir.
sir, for enlightening.
Manivel
Ma'am,
continue
yeah,
பண்ணு.
about, okay. Thank you so much, sir, for enlightening us patently. M. Karunanidhi, Assistant Professor of Physics and Coordinator of IPR Cell, to propose vote of thanks.
Thank you. It is my our secretary, advisor, director and the deans for their continuous inducement to do this two-day webinar on I and Assistant Professor, Tamilnadu National Law University, Trichy, for gracing your precious time and sharing your deep knowledge with on IPR filing and very informative session, sir. Thank you.
Thank you.
Thank you. I express my Dr. S. Lakshmi, Dean of Arts and Head Librarian, to organize the two-day webinar on IPR as Grand Manner. Thank you, Madam. I express my grateful to all the deans, HODs and all faculty friends from our institutions and other institutions for attending the webinar. Make it grand success. Thank you all. And I am thankful to all the members and audience of the meeting and all technical support for these sessions, this two-day webinar on IPR. Thank you. Once again, thank you all. Thank you. Thank you very much, sir.
Thank you for the
Thank you,
Thank
sir.
you, sir. Thank you, sir. And thank you all.
Thank you all of you.
Thank you all of you.